Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us today Brian Mandel. Brian, welcome to the show.
Thank you. Pleasure to be here,
So
Zane. Thanks for having me.
I'm glad you're able to come. So let me get my desk all adjusted here. I don't know why I'm having such a hard time today. So Brian is one of fewer than 1% of California attorneys certified as a specialist in estate planning, trust, and probate law. And he says there's no such thing as a bulletproof asset protection plan. And Brian, being a lawyer was actually your third career, but what finally landed you here? We're going to talk about the first two because I don't know about those.
Okay. Well, Zane, I studied biology in college, and I have a biology degree from the State University of New York. I grew up in New York City, and my first career was as basically kind of like a scientist almost. But I found out shortly after I graduated that there's no money in that. So I went into sales and I started working in Manhattan for a company that manufactured laboratory supplies and equipment. And I worked for them for several years, and they transferred me out from New York City to Orange County, California, which is where I still am. And that was about 40 years ago. And after I came out here, after a few years, I decided to go to law school and pursued a different path altogether. So I've been a lawyer since 1996.
So, have you, in that time, how did you end up on estate planning? That's an interesting journey, by the way.
Yeah, it's been interesting. It's been fun. Well, when I graduated law school, I was clerking for the Orange County District Attorney's Office, and unfortunately, that year, um, 1996, was a year that Orange County actually declared bankruptcy. They had a controller of the county who basically was stealing and wasting money, and he was kind of senile at the time. But uh, the
I
county had to,
remember this story, distinctly remember this story.
yeah, yeah.
It was big
I've
news.
it was a big deal because Orange County is a big county, and I think it was the first major municipal bankruptcy. But anyway, working for the district attorney's office, that was sort of my plan, was to go into that field and be a prosecuting attorney. But because of the bankruptcy, the county put a freeze on all hiring, so I had to go find a real job. And so I just looked around, and I went to my college uh, career development office, and they had listings back then. We didn't have the internet really, and I found a listing for a small boutique law firm in Newport Beach, and I applied there, and they interviewed me and got a job there. And I was just looking for any kind of job as an attorney at that point, and started working there doing estate planning and estate administration, and I really liked it, and I stuck with it, and I worked for them for about 6 years, and then I started my own firm.
So what was it like starting your own? I've asked this question to many attorneys because I have quite a few attorneys on the show. But what was it like the first month when you started your own firm? Did you have somebody in your hip pocket to go out and start, or did you just like how did that work?
Well, uh, you mentioned that I have the designation of a certified specialist in estate planning, and that's a special designation that lawyers can get if they've worked as an attorney for 5 years, predominantly in one particular field. And so I was working for that small boutique law firm, and my superior was a great guy, great attorney, but he was not a certified specialist. And I told him one day, I said, you know what, Dan, I think we should both become certified specialists. It's a good designation to have, it distinguishes us from other lawyers. And he said, yeah, that's a good idea. So we both applied to take the exam, and we both took the exam. And a few weeks later, after the examination, I got the result and I passed, and he flunked. He didn't pass it. So I, and that's really simply because he probably didn't study for it. I don't know. But anyway,
Mhm.
I then approached him. I said, Dan, I'm a certified specialist now, and I think, you should make me a partner. And he didn't want to do that. So I said, okay, I'll go off on my own. So I did. I left, and it was kind of scary, uh, but I didn't really take any clients with me. I started from scratch. Um, and the first few months were very hard. There was a lot of hard work because I was establishing all my systems and procedures and ways to go about doing the work that we do. And yeah, I didn't make as much money in those first few months, but probably after a year, I was making more money, I think, uh, probably twice as much or three times as much even as I was as a salaried employee for that previous law firm. So it really paid off very, very quickly. And it's been a lot
It
of
was a
fun.
good decision. Yeah.
It's a great decision.
So
Yeah.
you built your specialty around protecting assets. So tell me what's different about that than what do many estate type attorneys miss or in the
Well,
process?
well, when I started in working for that firm in 1996, the federal estate tax law was a lot different than it is now. Back then, if you owned more than $600,000, everything over that amount was subject to the federal estate tax. And the tax was very serious. It was 37% of everything over 600 grand. And so that was a big deal. It's a big problem for a lot of
Confiscatory.
families. Yeah, yeah, really, really tough. And it started at 37%, Zane, but it went up to 55% if you were worth more than $2 million. So just imagine, that's a big problem for a lot of families, even in 1996. Well, they raised the exclusion over time, and now it's $15 million. So it's not a big problem for many people at this point, but they raised it slowly over time. And I saw that eventually, with a 5 million, $10 million exclusion from estate taxes, that planning for that estate tax was not going to be a big part of the typical estate planning law firm's practice. So I developed another specialty, which is asset protection, which everybody's concerned about. Nobody wants to lose whatever they've amassed over their lifetime to some kind of a lawsuit or claim. So everybody's concerned about, particularly business owners. So I really started studying and developing expertise in that area. So the basic estate planning is great. Everybody needs that, a will or a trust to avoid a probate typically. But many people, especially business owners, are very, very concerned about losing what they've got to a lawsuit. And so I have developed strategies, techniques to help protect people from that. And that's been a really big and growing part of my practice for probably 10 years now.
So tell me what one of those strategies that has been most successful for your clients, and maybe if you can describe for me a specific situation, because those will always be more meaningful than the abstract.
Right. Well, first of all, you mentioned in my introduction that I don't believe that you can bulletproof your entire estate. And there's a lot of myths about that and rumors about that. If you go online, you'll see a lot of advertisements for how they can make a bulletproof trust for you and things like that. It really is not possible to protect yourself from every single uh, threat out there. But the goal of an asset protection plan is to protect you to the greatest legal extent possible. And I'll give you just one fairly straightforward example, and that would be a private retirement plan. Okay. Most people are familiar with a 401k plan, which is a retirement plan that falls under the ERISA rules. Uh, ERISA is the Employee Retirement Income Security Act. It's a series of laws that spell out how much you can contribute to a retirement plan and how much you can deduct from your income and so forth. Well, a 401k plan is that kind of a plan. It's an ERISA plan, and it is protected to some extent, but you can only put so much into a 401k plan. Do you have a 401k? You know
Hmm.
people that have those. So there's limits on how much you can contribute, and it's
Yeah.
not that much. For business owners that are making a lot of money and they want to take some chips off the table, so to speak, and safeguard them, California has a special rule, special law that's called a private retirement plan, which means that a business owner can put more money into a plan specifically designed for his or her retirement purposes. And this is money that's above and beyond what's contributed to a 401k plan. Okay. Now, the idea is that a private retirement plan, it's not tax qualified, so they don't get a tax deduction on that. However, they can take money or assets, real estate, cash, stock, whatever they want to put into it, really, and put it into this private retirement plan, segregate those assets, designate them as retirement assets. And under the law here in California, those assets are protected, they are exempt from creditors. So that's a really nice, clean, and fairly straightforward plan for retirement assets.
And
Yeah.
what kinds of assets can you put into that kind of?
You
Um,
can put just about anything. See, it's a private retirement plan. So you design it, you control it, you set your retirement age, and you can put pretty much anything that you want into that. Some clients put just regular stock brokerage accounts. Some of them put limited liability companies. They put real estate in there. You can put any vacation home, whatever you want. But the key thing is that once it's in that retirement plan, you can't use it. You can't just take the money out and spend it until you reach retirement age. So when we design these plans, we design them very carefully to show that it's a reasonable strategy. You want to show that these assets are necessary for the person's retirement. Obviously, you can't put everything that the person owns into a retirement plan like that because that's not reasonable. You have to live on things before you retire, right? So we put these assets into the private retirement plan. They manage and control those assets, but they cannot use them until they retire. But once they retire, they're exempt. So it's really nice. And it's only available to California residents.
Once they retire, they're exempt. What are they exempt from?
From judgments. So
Okay.
let's say a doctor or an architect or an engineer gets sued by somebody and they get a judgment against them, that retirement plan is going to be exempt from that creditor. Yeah, very
So
strong.
you could put your house in there, or you know.
Well, you can't put your house in because your house is where you live. That's not a retirement asset.
Okay.
So that's one exception to that. Can't put your home in there. There's
So
another
I just
there's another
Go ahead.
technique for your home. There's another thing for your home that we use called a qualified personal residence trust. It's another kind of a trust.
Is that within the state of California? Is that available
Well,
elsewhere?
that's a federal thing that you can use no matter what state you live in.
Okay, talk about that for a minute.
Well, the beauty of a qualified personal residence trust, which we call a QPRT, in estate planning, we're full of these, initials, QPRT, QPRT. That's a traditional estate planning technique to discount the value of a person's home. And if you think about a very wealthy person that has a $5 million home, even with the large exclusion that we have now, if that person's family is worth more than the federal estate tax exclusion amount, and they're going to be subject to the federal estate tax eventually, every dollar over that exclusion amount is subject to a 40% tax. So
Ouch.
yeah, so we want to discount the value of certain assets if we can. Now, the Cupid is one of those techniques where we can obtain a discount. It's been around for probably almost 100 years now. It's not new, and it's a very accepted technique for that purpose. And essentially, it works like this: you take your home, you put it into this trust, you select a term of years, maybe 20 years, 25 years, 30 years, whatever. Um, and during that term, you still live in the house, you pay the property taxes, you pay the maintenance on the property, all that. However, if you survive to the end of that term, right? At the end of the term, the property transfers to your children. So it's essentially a gift. So you're making the gift now, but the gift doesn't really take effect for several years later. And because of that delayed uh, gift, the IRS allows you to discount the value of the home. So we could take for example, $1 million house and set it up in a Cupid. And for estate tax purposes, we're going to discount that value to only $500,000. Okay. And that's going to save 40 cents on every dollar that we do that. So it's a very traditional estate planning technique. And because of that, it's really worth a lot as an asset protection technique because we want to use traditional standard strategies and trusts for asset protection because it's all part of building a reasonable story about why your assets should be protected. And in this case, we put a house in a Cupid because we want to obtain a discount. But the fringe benefit is that now we have fractionalized the ownership of that property. So now you don't own the whole property anymore. You have a right to live there, but that's certainly not worth the whole value of the house. So any creditor that obtains a judgment against you is going to have a difficult time putting a lien on the entire value of that home. And it puts the owner in a much better position to negotiate a better settlement on that property. So,
So
um,
that's interesting. I really wasn't aware of that structure. So that doesn't protect you like if you're in the um like people they go into nursing homes at one point or another, typically many people, and if they don't structure their affairs correctly, as that is, they see that impending, they have a, whatever kind of trust, revocable trust, irrevocable trust, um, however they structure it. I know that there's different ways that you can protect your assets from the nursing home just basically emptying your account and emptying all the money you had planned to leave to your children. Can you talk about that?
well, yes, that's a difficult situation. I don't get involved too much with that because most of my clients um, are wealthier than people that have to
Right.
go and are
That
worried
have to
about.
go through that.
Yeah, but I mean I've got a lot of experience in that nonetheless. Fortunately, here in California, uh, your home, your personal residence is exempt from qualification for nursing home benefits.
Mm.
Um, that just means that a person can have a home. and can still apply for Medi-Cal. We call it Medi-Cal here in California.
Mhm.
The rest of the country, it's Medicaid. But here in California, it's Medi-Cal, and you can apply for Medi-Cal and get the nursing home benefit even if you have a nice house, okay? Because the house is exempt, they don't count that. There are other tests as far as other assets. So it depends if the person is married or single, but the bottom line is if somebody's going to apply for Medi-Cal to live in a nursing home, uh, the uh, the uh, the the first test is the total asset test, and then there's the income test. And the income test is tough too because let's say somebody's getting a pension or retirement plans that they're getting income every month, and they go into a nursing home here in California. The nursing home charges, let's say, $8,000 a month to live there, but the person is getting $5,000 a month from his or her pension or Social Security or other sources of income. And so they call it the share of cost, Zane, which means that if the nursing home costs 8,000 and the person's got a stream of income for 5,000, well, that first 5,000 is going to go to the nursing home and the state will pick up the rest. Okay. But they still may qualify for the Medi-Cal to get that if they if their home is exempt and if their other assets are under the asset test, which in California, if you're married, it's something like $230,000. That's it.
Which now,
Uh,
if you own a home in California,
yeah, right. But the home is exempt. The home's exempt, so
yeah,
that's not a
right.
problem. The other thing also that's good about California is that if somebody does qualify for Medi-Cal, and let's say the state's been picking up the tab for a number of years, if that person has a revocable trust and the house and other assets are in that trust, then the state cannot put a recovery lien on the trust. They can only lien the probatable assets, which fortunately most of my clients don't have any probate going on because we put everything in trust. So California's got a pretty favorable rule against the Medi-Cal recovery liens, which is nice.
So if I'm a doctor or business owner who's never been sued, why should I be doing this now instead of just waiting?
Great question, and it's very important because um, any kind of asset protection plan has to be done in advance. Okay, it's kind of like insurance. You can't drive around in your car, cause an accident, and then call State Farm and try to buy insurance to cover that accident. Dude, it's not going to work that way. You have to put it in place ahead of time. And this is probably the biggest roadblock to an asset protection plan because every state has laws. They call them fraudulent conveyance laws, which means that you can't just take assets and give them away, put them in trusts, or transfer them to friends or relatives because you're afraid of losing them in a lawsuit. There are these fraudulent conveyance laws that says if you do that, we're going to claw back those assets and order those back to the creditors. So the plan has to be in place uh, before that because there are statute of limitations on these fraudulent conveyances. So, for example, here in California, the basic statute of limitations on a fraudulent conveyance is 4 years. So, ideally, uh, you would create your plan, transfer assets to certain trusts or individuals, and then hopefully not get sued within that 4 year period. If you are, that's potentially going to be a problem because that could be deemed by a court to be a fraudulent conveyance. Uh, yeah. So if you haven't been hit yet by a lawsuit, if you're a professional practicing, you know, you definitely want to have your professional malpractice insurance in place, but beyond that, you should have some basic asset protection planning in place too, even if you haven't been sued. Because once you're sued, it's too late. You just can't do an effective plan at that point.
So let's say I'm a business owner and I get sued, and but I feel like it's a frivolous suit. And I come to you and I said, Brian, I recognize. So tell me if this makes sense. I recognize that I can't protect my assets from this suit, but if
Yeah.
this just tells me that I could get in trouble at some point in the future, what can we do, not with this suit, but in the future, so that I'm
Right.
protecting my assets going forward? So what can we do now? Um,
Yep.
that can
Yep.
I be preemptive and
Yes.
recognize that
Yes.
talk about that for a minute.
I've had several clients that have done just that because that's a wake up call, right? It may
Hmm.
be a frivolous case or not such a big amount of money involved, but it kind of wakes you up to the fact that hey, maybe in the future I should be a little bit more proactive and do a little planning now. So yes, indeed, uh, if you're hit by a case like that, you should start planning, and maybe that won't protect you from that initial first lawsuit, but it will for any future ones. So uh, it's really smart to take that kind of thing as a wake up call and a call to action and start doing your planning before the next one is a real serious case, more serious problem, more expensive problem.
So why doesn't just hiding money or retitling it in someone else's name actually work? Can I get in trouble for that?
Yeah, that's a fraudulent conveyance. You will get in trouble for that. That's exactly what those laws are there to prevent. Um, you give something away on the day before the judgment comes down. That's not going to look good. Court's going to order that back, transferred back to the plaintiff, and they may fine you and surcharge you. And, some states even have criminal penalties for that. So no, that's not a good idea.
So what if I just decide, okay, I've got this IRA and I know I have a time limit. I know I'm going to be leaving this earth sometime, in the near future, and I'm just going to leave that IRA to the kids. Does that
Yeah.
work?
Well, with the
What could go wrong?
IRA, well, that's I think what you're thinking of is maybe non-IRA assets, because with the IRA, you've got the kids designated as the beneficiary already. But if you wanted to give them the IRA, that means you're going to have to take all that money out of the IRA plan, pay the taxes on it, which nobody wants to do, and then give it to the kids. So we're not going to do that. But
Right.
let's say you have a house or an extra house and you want to give that to the children. That's fine. That's great. People do that all the time. And the only thing to be a little cautious about is that if that's done in light of an impending lawsuit, that might very well be considered a fraudulent conveyance, and subject to the penalties and surcharges associated with that. But if there's no problem on the horizon, and if you can afford to do that, then you can do that. Yeah, no problem. That's not your asset anymore. You know, a lot of
So
people will do that, but hold it in a trust. So they'll take a house or an asset, brokerage account, something like that, create an irrevocable trust for the benefit of their children, but still retain the control of that trust as the trustee. But they don't really have any direct access to the money because they're not a beneficiary of that. And that's very strong protection too. But again, it's a gift. You're giving away the asset. You're still controlling it, but it's no longer your asset.
So I have a note here, and I'm not sure this was this research, and sometimes just gets given to me. Some of it's mine. It says, "What's a blowout, and why does it wipe out decades of growth in one bad decision?" But does that make sense?
Yes, yes, it does. I know what you mean by that.
Okay,
Um,
this is my staff. I didn't come up with that when I was
no,
wondering what
no,
is a
that's
blowout.
cool. That's cool. Well, actually, it's not that relevant anymore, but it used to be. Okay, it used to be with IRAs. Uh, on an inherited IRA, the children, who the non-spouse beneficiary, the children, if they inherit that IRA, they could leave the IRA in your plan and stretch it out over their lifetime, which meant that they could just take out a little bit of it every year, depending on how old they were, and they could leave it in your IRA. As long as it's still in your IRA, it's tax deferred. See, so it could grow and grow and grow, and certain, depending on the age of the certain beneficiaries, sometimes these IRAs were being stretched out for 30, 40, 50 years. Okay, and they were growing tax deferred all that time. So that was the stretch out plan. And the blowout that you're referencing would be where a particular beneficiary did not understand the benefit of the tax deferral. And instead, they just called up Schwab or Fidelity or whoever it was and said, send me my lump sum of my dad's IRA or my mom's IRA. And they would get a check for, 500,000 or $1 million or whatever, not realizing that now they have blown out the opportunity to stretch that IRA out for the rest of their life, and now they get a big tax bill because that's all taxable income to them in a lump
Mhm.
sum. That's the blowout. Now I say it's not as relevant anymore because several years ago, Congress changed the law on stretch out distributions from inherited IRAs. And now the children beneficiaries cannot stretch it out over their whole entire lifetime. Now it's limited to only 10 years. So it's not quite as big of a benefit because you don't get that lifetime deferral, but you can still defer it for 10 years. But that's what that
So
blowout was all about that your staff member found.
yeah, okay. Didn't know what that was. So if you've personally drafted over 2,500 estate plans, what's the pattern in the ones that go wrong?
Oh man, the biggest problem is the unfunded trust. Okay. Um, when we create your typical revocable trust, uh, we want to avoid probate. That's the general idea. Um, and and the trust will work great for that as long as there are assets in the trust. Okay. Now, as lawyers, when we create trust for people, we can draft uh, real estate deeds to convey the property into the trust. So when the client signs the trust documents, we have a deed for their home, we have a deed for their commercial property, for their investment property, for their vacation home. We prepare all these deeds. We have the client sign them right there in the office, and then we record the deeds. So we can get the real estate into the trust very easily. However, Bank of America, Wells Fargo, US Bank, Chase Bank, they won't let me take my client's account and put it into my client's trust. The client has to do that. So we try to help them. We try to help them as much as we can. We prepare letters for those banks, certifications for those banks. We instruct the client in writing, go to the bank, give them these forms, transfer your accounts into the trust. Okay. And I think most of them do it, but a lot of them don't. And that becomes a problem because later on, the client passes away, the children find the trust documents, they think everything is fine, but then when they go to that bank, they find out that the client never changed that account. And it's still just in the client's name. And now we've got a problem. We've got to go to court somehow to get that account transferred back into the trust. Not an ideal situation. and we try to educate the clients, and I think we do a good job of it. But every now and then, something like that falls through the cracks, and that's probably the biggest problem with revocable trusts, is they're not funded properly.
Hmm. That's
Yeah.
interesting. So, what's the most common phone call you get that means somebody waited too long?
um, yeah, I get a call saying uh, my my dad or my mom passed away. Um, I'm the trustee now. I don't know what to do. Can you help me? And yeah, sure. That's a big part of my practice. Come on in, I'll help you. And we start this process, and we go down the list of the assets that they have. And we sometimes determine at that meeting that, hey, there's an account at Bank of America, $300,000 never got put into the trust. Oops, what do we do now? All right. So there's that whole scenario. It's sometimes we'll get a phone call where they already have done that investigation and we know, but it's always kind of a bummer when that happens. But not much you can do about it.
So, is there a case where a client thank you years later for something that they didn't understand at the time?
All the time, every day. People
Every
people
day.
every day, Zane, people call me up, or they meet with me and they say, "Thank you for taking care of this for my family or for me," estate planning is a great practice because we deal with the clients. Sometimes we deal with the client's children or grandchildren, and clients' parents. Sometimes it's a real family affair, and I get to know people pretty well, and they get to know me. And I tell people that I have clients that have become friends, and certainly most of my friends are clients too at this point. But every day people tell me that they've achieved a little bit more peace of mind because of something that we did here, and that they've created a trust, or they've protected their assets, or they dodged this lawsuit, um, or that we've made it easier for them to inherit their house from their mom or dad. So it's a very rewarding practice. It really is.
So, what's a result you got for a client that still sticks with you?
Wow. Um, I I'd have to think about that for a while, but I guess there's one case where I did set up a trust for somebody, for a couple, married couple. The husband passed away, wife inherited from him, and his his daughter from a previous marriage sued the widow and claimed that he didn't know what he was doing when he signed the trust, and it should have all went to her, not the wife. That's a fairly typical scenario, as a matter of fact. It doesn't always go to litigation, but we try to protect against that. But in this case, this woman was really hell bent on suing her stepmother, and she did. She took her to court. I actually had to go and testify that I had met with both uh, spouses, um, met with her father, and that's exactly what he wanted to do. He wanted to leave it to his spouse, not to his daughter, which makes sense. But it's kind of a uneasy feeling to be testifying in court about something like that. But I did it, and it went to trial. And at the end of the trial, my client won the case, and she wound up with the house and won. So,
Seems like in, in a 50-50 state anyway, that would just automatically happen. But I can see people getting bitter about it. When there's
oh
money
yeah,
involved, everything's off the table, isn't
no kidding. I could tell you, well, I could tell you stories all day about that.
it? So, you served as chairman of the board for Jewish Family Service. How does that shape how you practice law?
Oh, interesting. Well, you know, Jewish Family Service of Orange County um, is part of the Jewish Federation here in Orange County, and basically charitable giving is a big part of estate planning for many families, and so that exposure, and that was many years ago, but that exposure with Jewish Family Service really opened my eyes up to all the great charitable techniques that we have to benefit charities throughout Orange County or the country or the world for that matter, in a way that not only benefits the charities, but with certain plan giving techniques, we also benefit the clients, you know, and they get tax deductions, they get income sometimes. It's just a really cool thing to do. It doesn't, not everybody's charitably inclined. I understand that, but a lot of people are, and thankfully so. So that was a great experience.
So if somebody's listening, and so you practice only in California, what parts of California? The whole state?
Well, yeah, I'm licensed in California as a whole state, but my practice is in Orange County. Uh, I have clients in Los Angeles, San Diego, Riverside, San Bernardino County, but most of them are South Orange County, which would
Okay.
be, Newport Beach, Costa Mesa, Anaheim. Well, Anaheim's North Orange County, Mission Viejo, Laguna Hills. It's not a giant geographic area, but it's a pretty big
It's a
county.
giant amount of people down there, though.
Oh yeah, millions, millions and millions.
Yeah, I'm really familiar with them. So, what's the best way to get in touch with you if you're in the Southern California area and you're thinking, I really feel like I'm exposed?
Well, of course, you can call me. Email is great too. My phone number is 949-660-0007. You can look up my website. I have a lot of information on the website. You guys found some stuff about the blowout and so forth, but email's a great way to contact me too. But phone call, email, text, whatever.
Okay, Brian, thanks for coming on the show. I really appreciate it. It was an interesting topic.
Well, it was fun. I'm glad you found it interesting. I found it fun, and you asked a lot of good questions, Zane. Thank you.
Thanks.